Very much. Thank you very much. Let me call this public hearing of the Joint Select Committee on National Security to order. I take this opportunity to welcome all present, and as well, let me indicate that this hearing is being broadcast live on the Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I want to particularly welcome the chairman and your accompanying officials of the Electronic Monitoring System Implementation Committee, as you are called, and officials of the Ministry of National Security, under whose purview you operate. I would like to invite you, ladies and gentlemen of this committee and officials of national security, beginning with the officials at National Security, to introduce yourselves.
Good afternoon. My name is Mark Lutchman, Project Manager with the Ministry of National Security.
Good afternoon. My name is Indira Haripal, Senior Human Resource Officer, Ministry of National Security.
Dale Prescott, Manager Solutions, Development and Implementation of the Ministry of National Security.
Yes, and other members, please.
Good afternoon. Terrence Dick, Sergeant of Police, Legal Advisor to the Criminal Investigation Department.
Good afternoon. I'm Radcliffe Boxill, Senior Superintendent Acting of the Trinidad and Tobago Police Service, CID and CRO.
Good afternoon. Dennis Pulchan, Deputy Commissioner of Prisons Acting.
Good afternoon. Narana Parsan, Attorney at Law, Attorney General Secretariat.
Good afternoon. Nadia James Reyes Tineo, Attorney at Law, Attorney General Secretariat.
Good afternoon. Tricia Hudlin Cooper, Assistant Director of Public Prosecutions, Office of the DPP.
Thank you very, very much. We are happy to have had your identification in those terms. And let me, for the record, indicate my name is Fitzgerald Ethelbert Hines, Chairman of this Joint Select Committee on National Security.
Paul Richards, Independent Senator.
Faris Al-Rawi, Member.
Wayne Sturge, Member.
Senator Michael Coppin, Member.
Nigel Freitas, Member.
And of course, this committee is very ably supported by our secretariat, led by the secretary to this committee, who is as well the clerk of the House of Representatives, Madam Jackie Sampson Miguel, and others of the Parliament. This inquiry carries inherently a number of objectives. I would like to outline them for all our benefits going forward. There are 4 objectives of this inquiry. 1, to identify the specific officer or officers and departments with the responsibility for reporting on and accounting for the various tasks and obligations as mandated under the Act and through directions from the Ministry of National Security. The second objective of this inquiry is to ascertain the precise current status with respect to decisions that have to be made with a view to the implementation of the Administration of Justice Electronic Monitoring Act 2012. Thirdly, to gain a full appreciation of the potential challenges or constraints in the implementation process. And fourthly, to recommend timelines towards full implementation. Let me acknowledge receipt of written submissions from the chairman of your committee. These were received on the 30th of January 2017 in response to requests made to you by this committee. I would like to ask, therefore, the chairman of your committee to make some brief opening remarks. You're welcome.
Thank you for inviting us to converse on the electronic monitoring implementation pursuant to the Administration of Justice Electronic Monitoring Act of 2012. As you'd be aware, the Ministry of National Security have been charged with the responsibility to operationalize the Act by way of establishment of an electronic monitoring unit, implementation of a system for electronic monitoring, approve the devices to be used for electronic monitoring, and of course, make necessary regulations to give effect to the Act. So I will stop at that point, and as we move along, I'll make further remarks.
In which case, I will questions to you, and we look forward to your succinct and accurate responses. I just must remind you that these proceedings obviously are recorded, and all that you say will be recorded in those terms. So, members of the committee, I would like to begin. Let me begin, Mr. Chairman, by asking or putting to you, in your submission to us dated January the 27th, 2017, you indicated that your committee was established on the 5th of August 2016. And with respect to the fulfillment of its responsibilities, I would like to ask, what would you say is the mandate of your committee?
The mandate of my committee is really to establish an electronic monitoring unit by way of bringing on board an electronic monitoring manager, deputy manager, acquisition of certain devices, setup of the system, and implementation of a pilot project. So subsequent to the pilot project, of course, then further decisions will be made as we move forward.
Now, your committee, as I have indicated a while ago, was established on the 5th of August 2016. The legislation that governs what you are about to do was passed in 2012. Let me ask, once your committee was established and you went to work, did you find anything or things accomplished in respect of the implementation of this system as you have described it?
The committee received their official instruments of appointment on August the 5th of 2016. Prior to that, there was some work being done on the Act under the then Ministry of Justice, and the portfolio of that Ministry of Justice had passed across to the Ministry of National Security in respect of this matter. And some work was done at that point in time, and when it came across to the Ministry of National Security, the Ministry of National Security had a review of it, and some decisions were taken, and some instructions were given as to how we should move forward with it.
I wanted to know, without belaboring this, whether any discernible, identifiable achievements were recognized as having been accomplished along the path to implementation. That's what I want to know.
In 2013, the order for the devices was made, right, and was signed by the then Minister of Justice,
Yes,
and that was accomplished. There was an interview process which was done, which had identified
Yes.
candidates for the position of manager and deputy manager. There was a process where the then Ministry of Justice had undergone to acquire devices and set up an electronic monitoring system. However, that process came under review under the Ministry of National Security, and there had been a change in the methodology being approached to that.
So persons were interviewed for positions in the unit? And
Yes.
but no one was recruited on the basis of those interviews at that time, from your knowledge?
From my knowledge, no persons were recruited at that time,
Yes.
right? And of course, that matter came across to the Ministry of National Security.
All right. Okay. Thank you very much. And insofar as the order for certain devices are concerned, that too did not come to fruition. In other words, instruments, devices were actually purchased or not?
No devices have been purchased
No
at this time.
devices were purchased. All right. Let me ask, insofar as the implementation is concerned, and this question I direct to you, but of course you can identify, or your members would identify who should answer this. What would you say your committee has achieved since your appointment on the 5th of August 2016 in respect of the implementation of the unit and its work in accordance with the law?
Since that time, since our appointment, the persons who have been identified for the position of manager and deputy manager, that has since been approved by the ministry. Those persons have been contacted and have indicated their availability to take up positions early March. And so the ministry will, during this period, be doing the necessary paperwork and so on to get that accomplished. In terms of a location for the electronic monitoring unit, we have identified and reserved a location for the unit, and that space is currently being prepared for the unit.
Where's that place?
165 Tragate Road, Port of Spain.
Where? Give me a little sense of where it is. I mean, Tragate Road is a long one.
It's, if I may, it's just down from Pat Raj Roti Shop.
All right then, I'll find out. I'll find out. Yes.
Or the Oval. It's like
All
about
right,
2-3
then
buildings west
yeah,
of the
yes,
Oval.
yes. All right. Now, you've spoken about the director, you called it? Or the manager?
Manager.
And the deputy manager. I take it that there are other positions to complete the unit. Is that correct?
Yes, there are
What
other
are
positions.
those other positions?
The other positions which have been approved are Senior Business Operations Officer,
Yes?
3 liaison officers, monitoring supervisor, and 5 shift monitoring operators. Right? Those positions will be filled subsequent to the manager and the deputy manager assuming their position to assist in that recruitment process.
And as you indicated, they are expected to assume their duties on the 1st of March.
Thereabouts, yes.
That's the man, and they will proceed now to
assist
bring on the other persons.
Yes.
All right. Members?
Mr. Lachman, you said that no devices have been purchased. When exactly do you intend to purchase these devices?
The strategy being adopted by the ministry is...
Can you just tell us when? A date. Let's not go the scenic route, a date.
Well, I need to explain where we are in the process.
Start with the date. Start with the date, if you can. If you can't, say so.
Well, I had presented in my brief a date of when we're going to engage the preferred solution provider, which is the 31st of May.
Right, so when do you anticipate then, or how shortly after, all positions are filled, how soon do you anticipate we can be up and running in terms of the actual operationalization of this act?
Again, the brief also indicated that the completion of the recruitment process will coincide with the date of the 31st of May by the engagement of that solution provider.
Right, so what I'm getting from you, in order to operationalize, we have to have certain positions filled, correct?
The key positions are going to be filled, which is the manager and deputy manager.
Right, but we can't operationalize and effect anything with just these two. You agree?
I agree.
Right, so how long after we get these two positions filled, how long after do you anticipate we'll have the other positions filled so that we can...
Well, like I said, by the 31st of May, we should have all the positions filled.
And by the 31st of May, we should have the equipment.
We should have a contract with the supplier for the provision of those equipment.
So you can give the people of Trinidad and Tobago an assurance that 31st of May is a day we can look forward to starting.
It's a day we can look forward to, provided everything goes as planned.
Okay, what do you anticipate could prevent us from starting on the 31st of May?
Well, like I was going on to explain, that the acquisition of the devices, of course, requires agreement, and we are pursuing certain government-to-government relationships to that. And once those things come to conclusion and fruition, we would have a party to be brought on board. Funding is always an issue, approval for funding. So once we get the requisite information and we make the application for funding, once the funding comes on time, we will have the funding available to enter into the contract.
Mr. Chairman?
Yes, indeed.
Good afternoon to everyone. Perhaps it's necessary just to ask a few questions so that the population can be included in the information which some of us may have.
Sure.
But really, the purpose of this public inquiry is so that the population understands what's going on. Now, of course, the panel before us, the team, represents a very diverse structure. Police, prosecutor for state, DPP, prisons, procurement unit of national security, Attorney General's office. And therefore, it's clear that there is a multi-sectoral approach so that persons who can be fitted with electronic monitoring devices can actually fall into the system. May I therefore, with a view to bringing the public into this equation, ask you a couple of questions?
Sure.
It would be, could you state, for instance, what the combination of events for operationalizing this unit will be? I know it's in your brief, but the population doesn't have your brief.
Certainly.
So, for instance, you've already told us you need a building, you may need IT, etc. Let me not put words into your mouth. Let me ask you to tell the population what are the coordinate elements to have a turnkey package afoot.
Certainly. Now, in accordance with the Act requires that there be established an electronic monitoring unit, which will have the responsibility for monitoring the devices that are out there. The court has the responsibility of delivering a sentence which would allow someone to wear a device. Now, so the establishment of electronic monitoring unit requires, of course, staffing and personnel to operate, as well as the devices, as well as the monitoring software and systems to monitor the devices, which will then be linked to the global positioning systems, and using, of course, our local telecommunication provider system as well to triangulate the position of someone, right? So to operationalize the Act, of course, requires those persons, the hardware, the software to do that. Together with that as well, there must be certain regulations as the Act requires as well to operationalize. So currently, the team is working on the policy for developing those regulations. Another aspect of the Act requires is that should somebody be in breach of an order of the court, then somebody has to respond. The Act specifies that the police service respond on those matters, right? So it also requires developing a response mechanism, and the police service has currently developed a framework mechanism already in place, which we need to further flesh out, as well as the communication mechanism that goes between the electronic monitoring unit to feed information into the police service, and for the police service to feed back information into the prison electronic monitoring unit, as well as have connectivity to the court system, because once the court gives an order, it must get to the electronic monitoring unit. And of course, there is a part to play with the prison service in the sense that should somebody be granted a device as a sentence, and they are in the prison service and so on, some warrant and some order has to be made to issue that and, of course, attach the device.
So, has public admin, is public administration arm of the government at work in ensuring the population of the unit beyond manager and deputy manager?
Yes, there is an approved structure, like I said before, with about 12 persons currently on board.
Has CPO set terms and conditions?
CPO set terms and conditions for the manager and deputy manager at this time, so we're pursuing filling those positions.
Is the judiciary involved in an exercise of sorting those persons who are currently in remand or under conviction who may be appropriate candidates for fitting of an electronic monitoring device?
What I can say, the involvement of the judiciary is that there are 2 members of the judiciary who are currently on the implementation committee, and they are advising us on how the judiciary will approach the matter. And of course, they indicated the necessary, once the act becomes available, the judiciary will then make the necessary changes to the sentencing guidelines and so on to pursue onto the act to be able to address those matters.
Is the government-to-government relationship that you've spoken about for the procurement of devices, is that, what state of negotiation or advance is that?
We have already had 1 presentation already, right? And we are scheduled 2 other presentations, so that for the other 2 parties that we will be having discussions with. So they're pretty advanced. So they are informing us of what their electronic monitoring solution is. And from that, the information will come to the ministry, and then we will make a final decision, which we will then, of course, approach Cabinet for a final decision on.
What about the telecommunications preparedness?
The devices, the information we have at this point in time from the providers is that the devices are compatible with telecommunications providers and so on, and can use their SIM cards. We have not formally engaged the telecommunication providers at this time until we have brought on board the provider of the devices so that we can have that technical discussions about protocols exchange and so on, and the technical matters that need to be sorted out.
Thank you.
Mr. Chairman. Your implementation committee hosts 12 persons. Is that correct?
Yes.
And we have 9 persons, if my count is correct, before us today. Who are the other 3 persons? And why are they not here?
The other 3 persons have sent their apologies that they could not make the meeting at this point in time. The other 2 members were from the judiciary, who have indicated that Paul and Jamie Filbert.
It's the Assistant Registrar, Mr. Virgil Paul.
I have a list.
And Ms. Jamie Filbert.
Yes. So, I'm sorry, member, what is that?
I'm sorry, I'm seeing that we have a Joint Select Committee list before us here.
Yes.
And on that list, Mr. Virgil Paul, who is the Assistant Registrar of the Judiciary, is indicated to have been here. So I assume that he's one of the 2 people missing. And so too, it appears, is Ms. Jamie Filbert.
And yet another, because I think we have 9 persons.
there
Which
may be
is
one
our legal director.
Yes. No.
Michelle Otley Jones, yes.
I'm not in castigatory mode, but I trust, Mr. Chairman, that you are satisfied that they had good reason for not being here.
Yes, yes, they have indicated their reasoning for not being here, so they're...
And then you mentioned a while ago, you know, you must note that when we have this kind of committee and we ask that members appear, we expect that they would, because we have issues to raise with various people, various office holders and members as might be necessary, okay? You did mention that on the electronic monitoring unit, there are 2 members of the Judiciary.
No, on the committee, our implementation
on this
committee.
Okay. But those names did not appear on the list that the Attorney General just made.
Yes.
Mr. Chairman, it's item 4, 9, and 10.
Yes. All right, great, great. Now, let me inquire of you. Now, the fact is that this bill, this law was passed in 2012. And this committee, your committee, was established in August of 2016. So we are a long way behind schedule. Am I correct? The implementation of this law, we are a long way behind schedule. Am I correct?
Well, if we check from the date of assent of the act, certainly we can come to that conclusion.
And therefore, I say that only as a backdrop to say that we have no time to lose. We really want to get on with this. And I want to say in passing again before I continue, that you did mention a while ago when you responded to my colleague's question about resources, you did identify finances, money, as a possible problem. Well, I just wanted to say the Ministry of National Security has been constantly, for many years, allocated the largest, or at least the second largest chunk of the national budget. Crime and its management happen to be one of the, if not the biggest challenge to this society. You hear it every day from members of the public. So, as chairman of this committee, I want to give you an assurance that we, as a committee, and even beyond that, we are not prepared to accept that money is going to be any challenge in this regard. This is a high priority for us. And when this legislation, the whole business of national security is a very high priority for this country. So I don't anticipate and I don't want you to contemplate money being an issue. After all, national security gets, as I said, the largest or the second largest chunk of the budget. And crime and its management are the most burgeoning problems facing us today as a people, and it affects everything. But more than that, this legislation was intended to overhaul the entire penal system and to introduce a new sentencing option which would have the effect of reducing prison overcrowding and introducing a more effective prisoner management system. The objective of these measures had to do with the rehabilitation of offenders, reduction of recidivism, all in a bid to ensure that offenders can become not only productive members of their communities, but productive members of the society at large. For the benefit of the public, I would like one of you to identify clearly what is electronic monitoring so that the public will understand what electronic monitoring is and what it can do to achieve the objectives that I have just read for you. Please.
Okay, John. The electronic monitoring system, as you said, is a sentencing options available to the court. So the Act provides for those persons to which electronic monitoring does not apply. So it's at the discretion of the court to apply it to a person. So now, electronic monitoring entails installation of an electronic monitoring device on the person who has been sentenced by the court. That device emits a signal which is tracked through the global positioning system and through the telecommunications information system that we have. And that information is monitored at a monitoring center, right? So the persons who are monitoring can know at any point in time the location of the person to which that device is attached. The device allows the flexibility of restricting the movement of that person within certain zones. So we can refer to those zones as an inclusion zone where they are allowed to move, and an exclusion zone where they are not allowed to move to. And should somebody be in breach of that order that they received, an alarm will indicate at the monitoring center. So that monitoring center now will be able to triangulate the person's position where that alarm has occurred. So once that has occurred, the monitoring unit is obligated under law to respond by way of contacting the nearest police station in the magisterial district in which that breach allegedly occurred. And the police officers in those stations under law is obligated to respond to that notification and locate the person that has been in breach of that. And once they have apprehended the person must be represented at court for further determination.
Mr. Lachman, you have regaled this committee and by extension the public about what this act applies to, and you've spoken about persons sentenced. Have you read the act, first thing?
Yes.
Do you not agree that the act also applies for persons who are not yet convicted and sentenced, in essence, persons on bail, and it also applies to persons who are the subject of a protection order under the Domestic Violence Act?
Yes, fully aware that the Act also covers persons who are on bail. It also covers persons subject to pardon as a condition of pardon, also to a domestic violence order. And also there are persons who can voluntarily apply to the court to have a device fitted.
Right.
Senator Coppin, I recognize you. Thank you.
Okay. Question to Mr. Lachman. I was reading your response, and one of the major challenges you identified was the exploration of an alternative method for the acquisition of various devices was undertaken to ensure value for money, and thereafter a government-to-government arrangement was explored. I myself have had a lot of experience. Well, I have had some experience in similar type systems that we tried to implement in the public service, and we had a number of challenges. Could you elaborate a bit on the type of challenges that you would have faced, which would have caused such a delay since the time you were constituted as a body till now? Could you elaborate on the type of challenges you would have faced in the procurement of these devices and the system?
Right. Prior to the team coming on board, of course, other parties had investigated various options. Now, we have to appreciate that electronic monitoring is new to Trinidad and Tobago's implementation. Also, we also recognize that we may not necessarily have all the technical competence to deliver on this, and realize as well that we need support. So we approach those governments that have had implemented these and seeking technical support from them. So first recognizing that we need the support, then we, of course, we reached out to the governments to give us support.
Was the iGov-TT at all involved in this exercise?
Initially, iGov-TT was involved at some point in time. The ministry, after review of the work that was done, they realized and recognized that we needed additional help.
So they are no longer involved in this exercise?
At this point in time, we have no formal engagement with iGov-TT.
And do you think that that's the best method, given the fact that that agency is mandated to bring about systems such as this?
Well, the ministry is currently engaging in discussions with foreign parties to give us technical support. When it reaches the stage of where we need the support of a special purpose state enterprise to facilitate the procurement process and so on, we will get to that stage and do that.
And are you confident that the undertaking you gave as to the, I think it's the May 30th deadline, is going to be met, given having regard to the fact that systems such as these involve not only the procurement of devices, but a telecommunication network service provider and discussions with them? Are you confident of this May 30th deadline?
We are pretty confident that we can meet those deadlines as we push along, because we understanding the urgency of the electronic monitoring system and the importance of Trinidad and Tobago. We as a committee is seeking to push as quickly as possible, accomplish our task in the shortest possible time as we can possibly can, hoping that everything works well and fits well. And as the chairman assured us, funding is not an issue, so hopefully we'll move on.
Sorry, I just wanted to ask, how often does this committee meet?
We meet on a monthly basis.
You think that's sufficient to to have things operationalized if you meet once a month?
Well, we meet formally once a month, but that doesn't mean communication stops. There's emails, there's...
But the decisions are made at the meetings.
Yes, decisions are made at the meeting, but there is work to be done when decisions are made. So we have to pursue work and report back to the committee.
Yes, but sir, correct me if I'm wrong. You are at the stage where you have a director and a deputy director, right?
No, they have not been brought on board yet.
Right, so we are very far. So after the director and deputy director are appointed, then you go to appointing a staff, correct?
Yes.
Right, and then you go to the procurement process, correct?
No.
No.
We are pursuing all those lines.
You're pursuing it now?
Concurrently, yes.
Okay, so when do you think that process would end so that we know when we get the devices?
At the point in time where we sign a contract, as I indicated, we are targeting 31st of May to sign the contract. And by that time, once we sign the contract, the devices will be made available.
Yes, but you still wouldn't be able to start.
Well, having the devices and so on...
Yes or no? You still wouldn't be able to start.
We'll have the devices and we'll have to test these devices and test the system.
Which means you still will not be able to start. The obvious answer is you still will not be able to start.
Well, at that point in time, once we have the devices available, we'll make the necessary moves to have it started. But of course, it cannot be immediate.
So more delays. It's reasonable to anticipate that there may be more delays. That's what I'm asking.
Well, in project management field, you also will have contingencies that you may plan for.
Just before I allow Senator Coppin to come in again, I am following the questions as asked by Senator Sturge. Senator Sturge, on behalf of this committee, and on behalf of the larger parliament, and on behalf of the public who are bleeding and suffering from the effects of crime in the society, they are not too interested. We are not too interested. We don't want any delays. This is urgent. Anything to solve this problem facing this country is urgent, and you and I know that this is critical, a piece in that puzzle. Senator Sturge is really asking to be given assurances that there are to be expected no delays. That's what he's getting to. And while I'm at it, a moment ago, I made the point about finances. I was not, let me make it clear, giving you any assurance that money will not be a problem, you know. I can give no such assurance. What I am suggesting is that you give the country that assurance, the Ministry of National Security, because you get the largest chunk of the budget. And it is up to the administration in that ministry, led by the Permanent Secretary, to find the money for this in their allocation aggressively. So it is not my assurance, Mr. Chairman. I can give no such assurance. It is that the public, on whose behalf I speak here, expects, important as this is, to reduce prison population and all the other very laudable things as you explained them, expects this to be implemented with promptitude, if I might say so, especially given that we passed this law in 2012 and we are now in 2017. They really don't want to hear, and I'm speaking on behalf of the public, they really don't want to hear anything about delays again. And we want assurances through the lips of Senator Sturge that your committee will be running hard, and therefore I know you hold substantive positions. He wondered whether your meeting once a month will be sufficient. So let me give way to Senator Coppin for his further questions. Senator Coppin.
Mr. Lutchman, I listened to you, and you would have spoken about the challenges. One of the challenges you appear to face is that of technical staff. Given the fact that in the past, filling positions, the two main positions, have appeared to pose a challenge, how does one envision procuring the relevant staff for the rollout of such a system, given the past history given the past history in not being able to procure relevant staff? Could you tell us a bit more what is your plans going forward?
I don't think essentially we had a past history of inability to procure technical staff. I think once we engage through GHRS and so on and advertise properly, I think there are enough citizens in Trinidad and Tobago who are qualified to fill those positions.
So you don't foresee that it will require a degree of specialist skills and training that will not be available by your May 30th deadline?
I don't envision that there will be persons in Trinidad and Tobago who don't have the ability to perform the functions that are required of this unit.
Let me just ask quickly on Senator Coppin's question. Have you all advertised as yet for these positions?
Like I indicated, we were waiting on the manager and deputy manager to come on board.
But why do you have to do that? Since you know what the positions are, you can advertise them. When the deputy manager and the manager comes on board, they can become part of the process. I understand the logic of that. But nothing stops you from advertising now and conducting interviews later on or whatever else has to be done, vetting and a lot of stuff. But you certainly can advertise now. In other words, as I said a while ago, we want to get this ball rolling. We are behind schedule, and the need is great. So I don't understand, and you must convince us, why couldn't you, or why have you, or why can't you advertise these well-known positions as we speak?
Yeah.
And those persons are expected to be on by the 1st of March, 1st of May. Could you tell us? You don't have to take all of the answers. You know, there are other people around you, well-paid and well-professional. Please. But, Mr. Chairman.
Your suggestion is taken under advisement, and yes, it's a good suggestion that we could approach the market now and advertise for persons.
In other words, we want your committee to be far more, along with your peers, to be, let me not say far more, to be acutely proactive. No time is to be lost. The situation in the country is grave.
So we expect that by next week, the advertisements would go out?
I will have to consult with the HR department.
More talk. That is what consultation is, talk, more talk. Just to send out an advertisement.
Do you even have
I
a
would
structure?
appreciate
Sir?
that.
Do you even have a structure for this unit?
Yes, there's a structure we approved and so on. by the PMC.
Can I ask one of the lawyers, with respect to the legal contracts, who's responsible for dealing with these contractual issues?
Member, if I may, it would be the permanent secretary who will be taking on these persons as the employer.
Right, but you know, the permanent secretary being a public servant and all that goes with it, that would take some time.
Unfortunately, I'm not with the Ministry of National Security, so my apologies, sir, for not being able to address that particular statement.
Yes, but
let me say, the committee reporting to the permanent secretary as it does can say to the permanent secretary today, we would like to have an advertisement placed for these positions. Is that correct, Mr. Chairman?
Yes.
Yes.
Yes. Your suggestion is taken under advisement,
Yes.
and we will seek to act on it.
Great, Senator Coppin. And by the way, before Senator Coppin, and anything else that can be done now should be done now. There's no time to lose. Senator Coppin.
Have you identified a criteria for the identification of firms that you hope to provide a solution? Have you identified a procurement plan for these firms?
That's why we approach the various foreign parties, the government arrangement, to help assist us with the definition of some. And they have done that. Like I said, one party have already given us a presentation on what that entails. We have 2 other parties scheduled in February to do that. And
firms from what countries?
We gotten support from the British High Commission, from the Canadian High Commission, and the U.S. Embassy.
Okay. A final question. Why 300 devices?
That is targeted towards a pilot project. Once we get the contract settled for the devices, we move immediately into a pilot project in the St. George West Magisterial District. And that would be our test case, and that would give us all further information as to how the system should be properly operated and run before we move it nationwide.
So you have a rationale for 300?
Yes.
But can I ask, I see Mr. Pulchan here. Mr. Pulchan, have you considered looking at your prison population and the types of offenders this legislation may apply to? Can you give us an idea as to how much more devices we may need beyond the 300?
The remand population of the prison service is approximately 2,200 inmates. The 300 we speak of is in the pilot project. And,
I know.
there are those inmates who will not be considered for use in this program, those of capital, as the act
The schedule,
outlined.
the full schedule, yeah.
But I think we may look at about 1,500 in the first instance.
So that we should be looking for a program that has a capacity of between 1,500 to 2,000 persons.
More or less, yes, sir.
And that has been communicated to the committee?
We have discussed that, sir.
Meaning you've communicated that we should be looking at 1,500 to 2,000?
In the long term, yes. But at current, we discuss the 300 pilot project.
Okay. Can I ask, and the lawyers, maybe the lawyers might be able to help. I heard about developing a policy to decide on regulations. Do you have precedents in mind, and from which jurisdiction in terms of precedents of both the policy and the regulations?
Member, if I may, under the former Ministry of Justice, research would have been done in looking at various jurisdictions to see what may be best fit and adapted, not adopted to our particular situation. But I can actually speak from my personal experience, having been in that position at a particular point in time. We faced immense difficulty in the absence of technical expertise, this particular system not having been in place before in our country, to see what would be the best fit for us. And at that particular point in time, it was felt that it was best that the service provider who may have come on would have possessed the requisite knowledge and experience to guide the formulation of regulations as required under the Act.
And you've identified the service provider so far?
No, we have not, Honorable Member.
Right, so we haven't even gotten to the contract stage, and we haven't gotten a service provider yet, so we have to get the service provider first, and then we'll get into the procurement and the contracts and the regulations, and all that could happen before the 31st of May. That's realistic in this country.
Member, if I may, because I just want
Yes.
to clarify, when I spoke previously, I spoke in terms of what would have been done prior,
I understand.
some time ago.
But since there's no service provider identified, then we're not even really at procurement stage and contracts for procurement and regulations and policy for regulations and which is the best precedent and so on. We are very far from what I'm hearing. So May 31st basically is you all selling us dreams. Well, not you all, but the chairman in essence was selling us dreams.
If I may, sir.
Yes?
I apologize. The intent under the former, as Ms. Parasad would have indicated, excuse me, was that the provider of the devices would also be engaged as a service provider, so that the request for proposal would have spoken to that in two elements. However, I understand through the chair, upon revision by the Ministry of National Security, the intent is when the provider of the devices would be brought in, that entity, I'm not saying would be treated as service provider, would be consulted also with regard to any additional technical support that may be required. So the format of the procurement, if I may so describe it, has somewhat changed from what Ms. Parson would have been speaking to.
And do we have a guarantee it wouldn't change again?
I can't say, sir. Mr. Chair
so
would have to
we're gonna
respond to that.
spin out of
Let
control.
me say something here, that I know you're alluding to pie in the sky and so on.
Well, selling dreams.
Selling
yes.
dreams and so forth and so forth. But as a committee and as a ministry, we believe, and we are working closely with the Permanent Secretary and all the officers of the Ministry of National Security to ensure that we keep to these deadlines and meet the requirements of the government of the Republic of Trinidad and Tobago.
So can I
In
just cut
doing
you and
this-
ask if you have, and you can share with us, timelines for each of these things? You have timelines you can share with us?
I provided the timeline for you in the brief, but if you want me to repeat what the timeline
Yes,
I have.
for the benefit
Plan
of the
for
public.
implementation
Yeah.
of the system.
Yes, we
Yeah.
do.
Right, for the benefit of the public, so that the public hears and the public can make an adjudication.
In terms of bringing on board the deputy manager, the manager and the deputy manager, early March, but beginning of March, we will do that. Right?
Deputy manager,
By the
March.
31st of May, we will complete the recruitment process for the other staff members. That does not say that all is going to come on the 31st. There is a schedule, and we'll bring those persons on board. Right? By the 31st of May, we would have had the engagement of a solutions provider. Right? By the 30th of June, we would have completed the police response mechanism to the Act. By the 19th of July, we would have had the proclamation on the Act and the regulations and so on.
Right. So June and July would be after the 31st of May that you told us about, right?
Yes.
Right. Okay, go ahead.
Right? And then, of course, we're going to start the pilot project on the 1st of September.
Yeah, but you just told us that by the 31st of May, we would have the other staff, right? But isn't there a training element?
There is a training element.
Which could happen after 31st of May.
It could happen, yes.
Right, so then we are reasonably or virtually certain that the 31st of May would be you selling us dreams. From all that you've said.
I don't know how we arrive at that conclusion.
Okay.
Member
but
Sturge, if I
maybe
may.
that is.
In order to prevent some intriguing let me invite Senator Richards to pose some questions.
Thank you, Mr. Chairman. Good afternoon to the committee. Not to belabor the point, but just to ask some questions to get some context.
Sure.
And as the chairman has indicated, the questions may be directed at Mr. Leshman, but please feel free to delegate to any member of your committee who you think may answer correctly. But to start with you, how many times has this committee met since its inception?
Roughly, officially, 5 times.
5 times, more or less.
5 meetings.
Given and you're comfortable with meeting once a month to achieve your deadlines?
Roughly, yes.
You have not met all the timelines so far. You still comfortable?
I'm not sure what you're referring to when you say I haven't met all the timelines.
There have been delays articulated. In project management, as far as I know, one must forecast possible obstructions, some delays, some issues that may come up, and put redundancies in place to facilitate expediting past those delays. In addition to finance, what are the other major, if you could identify 3 major issues that, as a committee, you may have discussed that you think you have put redundancies in place to mitigate against? And it would be helpful also if any of the other members of your committee could possibly go in turn and identify what their challenges may have been so far and what their forecasted challenges may be in addition to finance.
Okay, I will ask Mr. Terence Dick and Mr. Boxell to give some information on what some of the challenges that they foresee.
Well, it's not a major, honorable member, it's not a major challenge, but we foresee training and sensitizing officers as to the various powers vested in the police under Section 17 of the Act, where there are violations. We have to train and sensitize officers. We don't intend to reinvent the wheel. We have units within various divisions who can respond to where there's a need for the police to act or arrest someone who would have been in breach of the act. But the basic thing is we await the procurement of the chosen service provider, so we would know what level of training we need to give to our personnel.
Thank you, Mr. Boxell. I'm asking these questions so the public also gets a sense of the challenges that you're encountering, which may have caused the delays, and hopefully what systems you may have put in place to expedite past the delays that you've already encountered and that you may encounter. Anyone else? But the context also that May 31st is 4 months away.
I would ask the senior HR officer now to indicate some of the challenges that they may experience in the...
Actually, we don't foresee any challenges, given the fact that you indicated that we should advertise. I will do so tomorrow. I will send the file to the PS to advertise the position, and we will move forward with that.
Can I ask a question with respect? As a committee in charge of managing this project, I don't think, and I can be wrong, the public will be comforted with the fact that a suggestion would have had to come from members to do that it can be a concurrent or parallel action while other issues are taking place, especially given the delays. Had that been discussed at all by the committee, given the delays you've encountered so far, to expedite past deadlines that you've missed already, and other issues that you may be able to mitigate against that would have occurred?
No, I will reverse. What I would say is that, remember our committee took up office on August the 5th of 2016. And so I wouldn't say that our committee has had significant delays in pursuing our course of action. Yes, granted, the act was assented to since 2012, we received our instruments of appointment on August the 5th. And we are working assiduously to get that done as quickly as possible. We are co-opting support of all the relevant stakeholders that we need to try and do this as quickly as possible. And I'm glad you mentioned as well the project management. As you would know, that in any scenario, you would have a best case, an average case, and a worst case scenario, which we will all look at. We would hope that we always achieve the middle ground. Of course, there are things that can go wrong, which we will have to deal with, and which we'll have contingencies in place to deal with and manage, right? So to say that the committee itself has not been delivering on its timelines, wouldn't fully agree with that at this point in time, but we are working, and we are working with all the relevant stakeholders. As you see, the committee itself is a cross-functional team with a lot of expertise from different areas of life in Trinidad and Tobago, right? And I think we are pushing, and I think everybody understands the importance of getting it done quickly. I know, and I understand that we put a challenging timeline for ourselves towards you. And yes, you hold us accountable for our timelines, right? But we understand that. We understand the challenge that we have to do this. And we understand the level of work and dedication and commitment that we have to put to achieve these timelines. But we are willing to do that.
Is part of your implementation process a public awareness program, given that this is a new protocol being introduced in Trinidad and Tobago? The population is already tense. There may be misunderstandings about what this entails and uneasiness if the public is not fully apprised and aware of eligibility criteria, how it will roll out, and systems in place that they can feel safe and assured that those who are eligible and become part of the program will not pose any further danger in an already extremely trying criminality in this country.
Yes, granted that there has to be a public awareness program, but I don't think at this stage in the committee that we are ready for a public, because we still have some clarity which we need to work out with bringing the provider on board, properly completing the design of the system.
My question wasn't, excuse me, my question wasn't if there can be at some time. Is it already part of your documented process?
Yes, it is. It is part of our process to have.
Thank you.
Mr. Boxer, sir, you did mention section 17 of the Act. Before I ask the representative of the Office of the DPP to tell us how does this law impact the work of the DPP, and how did the Office of the DPP impact the work of the committee in the context of its urgency and importance, before I raise those issues with the representative of the Office of the DPP, I would like, for the benefit of the public, now you just spoke about section 17, remember?
Yes, Honorable.
And you spoke about the need for training in this regard on the part of members of the police service, whose job the chairman told us would be to deal and to intervene with breaches of this law. What is section 17 in essence all about?
Well, it deals with where a person tampers with or fails to comply with the order of the court as it relates to the device. There's a process by which the police would be contacted when there's an alarm, and we are required to act on the directives of the director. The section indicates that there is a fine of $100,000 and imprisonment for 2 years. It refers to tampering with the device or causing a disruption, any disruption in the transmission of the monitoring signal of the unit device. And yes, that's what section 17 refers to.
Okay, and finally, it just occurred to me, because the chairman told us that an alarm is triggered if the person went outside of the allotted or the ordered space. If he's told not to cross Frederick Street, west of Frederick Street, once he does that, the device triggers an alarm in the monitoring unit. They then contact the nearest police to treat with that breach.
Yes.
That's my understanding.
Yes.
Is there, from the little you know, any device that itself begins to alarm loudly on the person of the individual, to alert persons around him that he's wearing a device? By chance, did you come across any such thing, or should we invent one?
No, we have not come across that, but I was told that it would vibrate, so that the person wearing the device...
I wouldn't hear the vibration.
No, you will not hear it.
My life is in danger on Shakan Street.
The
But
light...
if you coming across Queen Street from Frederick Street and the things start to go loud and thing, everybody in the country and around them will know that that man is hot.
Well, maybe we ought to consider suggesting that to the chosen service provider.
I don't know, I just asked.
That's a reasonable suggestion.
So not only the monitoring unit will become aware, but persons around him, because he's in breach of this domestic order now and he's going. So if this thing triggers a loud alarm, I don't know if it works like that, I don't know, but it's just a thought that came to me. Let me give way now, let me give way to the office of the DPP to tell us, as I asked a while ago before Senator De Freitas poses his question, how does this, the implementation of this, how do you see this affecting the work of the Office of the Director of Public Prosecutions, and how did your office impact the implementation of this so far and going forward? I would like to hear the word of the DPP in this.
Good afternoon, Chair and members of the committee.
Good afternoon.
The work of the Office of the DPP in terms of the actual in-court presentation, because we do not do any of the investigative work or the apprehending work, as all would be aware. It is really to see which offenses really would be a best fit in terms of those offenders for whom this will be the best program. Of course, it will affect what we suggest in terms of conditions of bail. It would also affect what we recommend in terms of sentencing, what we posit to the court in terms of sentences and so on, so that we do not really need more manpower to treat with it. We would have, from the limited staff we already have, this is something that we can work. It is really a matter of law in terms of what we posit to the court and the court taking on board our suggestion, as is customary when one looks at bail and when one looks at sentencing. It is not only the word of the prosecutor. The probation officers are involved, and also if the person is already incarcerated, they would send for a biosocial report and those kinds of things. It is usual now that the prosecution would present a victim impact statement. Those things are considered. So it is really putting all of that before the court, looking at what the different reports will throw up, and then the prosecutor being in a position to best assist the judge as that court seeks to make an appropriate sentence and or impose bail in conditions where this applies. In terms of the impact what contribution we have made to the team in considering all of this, we would have looked at the different sentences, particularly the issue of the schedule where drug trafficking was one of the offenses included as one of the offenses that should be excluded, so that this is not one of those things that somebody who is convicted for trafficking, it cannot be considered in lieu of sentence for someone in trafficking, and the team has discussed that in terms of perhaps a further recommendation at a later date. It does not have to affect the implementation now, but as one of the things that we can recommend going forward that may be ripe for an amendment in terms of allowing someone with drug trafficking, that person can be a candidate for monitoring. Sure. Indeed. Yeah, sure. So if I may, Chair, on your invitation, the first schedule of the Act provides a list of offenses for which electronic monitoring may not be imposed by way of a sentence or in lieu of a sentence. That simply means in place of a sentence. For 1, treason. 2, offenses against the individual, namely murder, conspiring or soliciting to commit murder, manslaughter, and shooting or wounding with intent to do grievous bodily harm, unlawful wounding. Also, offenses involving kidnapping, namely kidnapping and kidnapping for ransom, and knowingly negotiating to obtain a ransom. Drug trafficking, namely trafficking in a dangerous drug and possession of a dangerous drug for the purpose of trafficking. Unlawful possession of a firearm or ammunition. For these offenses, one cannot implement the electronic monitoring in lieu of sentence or as a condition of sentence or as the sentence.
Further consideration.
Indeed, and we
as
have
far as the
discussed
office of
that.
the DPP is concerned.
Indeed, and as part of the team, this is something that would have initially jumped out at us because it is something not only that may be one of the offenses that should be considered, but it may also provide a useful tool by way of gathering further information, because sometimes persons involved in the drug trade normally are not involved alone. And so it may provide a tool by which one can garner more information that may prove useful in the fight against those offenses.
Thank you very, very much. Senator De Freitas, I give...
Good afternoon, everyone. We've been focusing quite a bit on the implementation and the setup of the program, and I just wanted to switch gears a bit and speak to the response mechanism that is being developed, the preliminary design. What I wanted to ask is, do you have a preliminary design already for the response mechanism? And a lot of the questions that I'm going to ask onward from now on is really to seek clarification, because I'm wondering about that response mechanism and its robustness, assuming that the implementation goes according to plan and you're able to hit all of your targets. So do you guys have a preliminary design for a response mechanism, assuming that everything goes according to plan? You have the infrastructure, you have the human resources, you have the devices. Response mechanism, do you have a design?
Good afternoon, Honorable Chairman and members of the committee. My name is Terrence Dick. I am the legal advisor for CIDCRO. As it relates to your question, the response plan comes from the police as it relates to recapturing these persons who would have breached the order by virtue of going outside. We would have indicated to the team that we have task force set up in every division in Trinidad and Tobago. We would have also discussed a liaison officer who would carry the rank of either superintendent or senior superintendent, because we know if the civilian member were to call the station, obviously you may not get a timely response. So we would want someone with a particular rank to communicate with the division or the station to say, listen, the director has indicated that a breach has occurred, and you would get a real-time response going forward. So you would contact the division, you would have in that division a task force, or you would have either a response unit by the RRU or the E99, depending on the division you call. Because there are some divisions you may not get an RRU, but you may have a 999. So the director is going to call the senior superintendent and say, listen, he's going to be called on 24/07, so that he can, because the breach could occur at any time. So you would want this person to be recaptured immediately and brought to the station or in order to deal with it. But what we have found out is that let's say you have a situation where an investigation has to take place. So someone has led, let's say you have a subnormal person that was ordered to wear the bracelet for whatever reason, and that person was lured out of the division. You would want at least the sensitization from the police, which is one of my functions in the CID, that I sensitize the police service or the legal or the police officers that would be trained in this. They say, listen, this is how we approach it. This is what you would need to do. And I would communicate with probably the senior superintendent. So you get a real-time understanding of what is taking place. We would have discussed that as a team. We would have also mentioned that when the implementation takes place, this officer would be on board immediately. So the breach, the response mechanism or the framework is already set up. The training, the sensitization, the fact that I am one of the officers that actually go around to the division, audit where we identify the sensitization takes place, because the law is there. It's just a matter of bringing the understanding to the police officers. This is something new. Officers, to get an understanding of it as the police service, as we all know, sometimes it takes a bit of time. They tend to learn better from someone who is teaching them it from inside. So the police service, myself, Mr. Boxill, we would have engaged the Deputy Commissioner and said, listen, we need to get this on board. We have our mechanism in place. It's just a matter of getting the senior superintendent on board, and we respond to this when it occurs. And those persons we would have identified, the task force, the response unit, the 999. So you always have somebody that you can call.
Yeah, I just wanted to, okay, and the answer is pretty good in terms of the fact that you guys have that response mechanism sort of fleshed out already, so that when the implementation comes in, you're not now looking to design a response mechanism. So I just had a few more questions for my clarification purposes. We are now implementing monitoring as it relates to the laws of Trinidad and Tobago. And we have offenses that when people commit, they're bailable. Are there restrictions imposed now, as it is, on those individuals when they get bail for certain offenses, or is it that they are free to move along the country? Let's say they could fly to Tobago for a weekend. They're out on bail, they could fly to Tobago for a weekend and come back to Trinidad, meaning that there's really no restrictions as long as they remain within Trinidad and Tobago. Is that the case now, or under our laws as it is, minus monitoring, restrictions are imposed on people who are out on bail?
If I may, Chairman and Honorable Chair, what I know happens now is that different courts and different judges have implemented a system of curfews. I know that there is in the courts now a system of bail monitoring where there is a police officer who actually does the community policing aspect of it and is assigned to that particular offender by way of tracking that person. So now in the courts, the judges have imposed curfews on offenders, different offenders, young offenders, and for different offenses. They also have implemented restrictions in terms of their whereabouts and times. If they are working, they are told what time they are going to be allowed to go X, Y, Z place, and they have to be back home by a particular time, and the officer reports back to the court as to whether that person has been good in relation to that or not. If the offender is beneath a particular age, I think we go 21 or so, but some judges have monitored beyond the age of 21, are monitoring beyond the ages of 21 and so. Those offenders are called back on a regular basis to the court to account for their whereabouts. They also have to appear at the police station at set days, at set times, which is also a way of monitoring them. And then they bring that book with that record to the court, and the court would look at it and see what needs to be adjusted in terms of their bail conditions or not. So there are two systems of monitoring now that the judges do, but they also impose curfews and restrictions that way.
Okay, the reason I was really asking that is because I was wondering, given the device and its capabilities, if what are the chances of false alarms happening? So for example, within the restrictions given by the court, let's say an offender is allowed to at least go to Tobago for the day for whatever reason, when they enter the plane and the plane takes off, if this would lead to a false alarm, or if these devices are built in a certain way that this would never happen.
If I may, Honorable Member, the issue in terms of the court order, that court order is would be immediately transmitted to the unit. The officers attached, the liaison officer attached to the unit would have that court order, so that if the order before had countenanced that the person would not be allowed to go to Tobago, and there is a variation, that variation is immediately transmitted to the unit, so that that no longer is flagged as a breach if that person is on a plane and beyond, a certain distance from where he needs to be.
But if the person is allowed to go to Tobago, let's say that's not a restriction, being on a plane flying between Trinidad and Tobago isn't going to cause a problem for the device?
It should not, in terms of what we have already had from the presentations.
It's very similar to the domestic violence regime, where when the court makes an order, 3 copies are issued, one for the victim or beneficiary of the order, one for the police service, and the other one for the offender. So the relevant parties will be aware. I take it that that's the sort of approach we're taking here.
Yes, Honorable Chair, and then we have to also, because of the way the act is structured, the manager of the unit, the person in charge, that person would also have to be made aware of the order immediately, so that they know what's happening.
Before I give way to Mr. Richards, Senator Richards, I must say, Sergeant Dick,
Yes, Honorable.
I appreciated your discourse and the explanation you provided a while ago, but there was one little element of it that troubled me. It had to do with a rather matter-of-fact, a passer comment in justifying that as you proceeded with this training, there's a particular officer in each division to whom the member of the public could contact to ensure swift response from the police. And as you went past that, you mentioned, well, you know, the public really doesn't get immediate responses from the police otherwise. That troubled me. That troubled me. This committee, speaking on behalf of the Parliament, now what you say might indeed, and one anecdotally takes it to be true. But you, as a professional police officer, and Mr. Boxill, and the Minister of National Security, and the Commissioner of Police cannot accept that to be true. So I just want to place on behalf of the committee, we do not accept that to be the norm, though we admit that unfortunately, in many cases it has been. But the police has to work equally hard to find mechanisms, just as you did in this situation, to ensure that when Mr. or Mrs. Public calls you, they get a prompt response. And I must say, before I allow Senator Richards to come, the reason why it may unfortunately be true that responses are not always forthcoming from the 7,000 officers who populate the police service and from other arms of the state public service apparatus is because a lot of people in this country are being paid to do jobs and they are simply not doing them. The whole thing has almost collapsed. Supervision is sometimes non-existent, and we now accept that a member of the public could go to the hospital and don't find a nurse, or go to school and the teacher not there, and these kinds of things. When it comes to the police in this crime season, work equally hard, Mr. Dick, and I know you are working hard, to ensure that the public gets a prompt response 24 hours a day, electronic monitoring or not. That's what we expect.
Permit me to remedy that statement, Honorable Minister.
It has been remedied.
But, Mr. Chairman, I just to piggyback on your question before the other Senate members get a chance, have you, Mr. Dick or Mr. Boxill, formulated in your mind what would be the response time, like 5 minutes, 10 minutes, so that we can give the public the assurance that within 5 minutes or 10 minutes or whatever time you came up with, we can have the police on the offender, so to speak?
We would hope to be able to respond as quick as possible. To give a response time, there are a lot of variables that may impact on the response time of the police.
But an outside response time as a standard, so that it would not be more than 15 minutes. Have you arrived at an outside response time?
Well, we would want to respond immediately, but the system tells us of a process where there's a need to communicate a particular way with the police through electronic or in a written form. We must receive this in an official form. But once we get that communication, we would try to respond as quick as possible. Mr. Dick indicates that we would be using the divisional task forces who are all over the country in all the court jurisdictions, and we hope that once the information is given, we get a prompt response. And this is why we have chosen to have someone at the rank of senior superintendent or superintendent given the instructions so that he can direct persons.
But can I just ask quickly? I haven't seen it in the regulations, but don't you think, given the culture in not only, well, the police service being a microcosm of wider society, do you not think it's time that we look at amending the laws to penalize officers who use police vehicles for reasons other than police work, to criminalize that?
Well, criminalizing is against the regulations.
Is it enforced regularly, these regulations?
Well, enforcement is supposed to be done at the supervisory level. Accountability at the level of the station supervisors. All police vehicles now are fitted with GPS, so it's easy to locate them, and you can even restrict them to certain areas.
Right.
Mr. Chair, if I could.
Yes, indeed.
Following from Mr. Chairman's commentary and others' questions about the response time, and the fact that in some situations, and I'm reading from the Schedule 2, where the Domestic Act is amended, Domestic Violence Act is amended, in Section A, by inserting the following subsection, the court may also impose electronic monitoring on the respondent as a condition of a protection order in accordance with the Administration of Justice Electronic Monitoring Act 2012. Someone who is depending on this as a monitoring device where a situation of domestic violence is concerned really cannot depend on a relative response time. Because if the response time is not, how should I put this? Swift, it could have deadly effect, as we have seen in the past. In addition, and just before you answer that, I'll pose a question possibly to Mr. Prescott, who is the Manager Solutions Development and Implementation ICT Unit of the Ministry of National Security, following from Senator Member De Freitas's question about the robustness of the service provider and his concern about aircraft travel and the loss of signal. In doing research before this, there are many jurisdictions that have cited, even with the most reliable ICT providers, dropouts in some buildings, dropouts in certain areas of the allowed area, and how the committee intends to deal with that, because then someone who's eligible may go off-grid. False alarms, through no fault of their own, and these are real practical considerations that must be addressed, even, I would imagine, or at least discussed, even before the pilot phase is implemented.
Good afternoon, Chair and committee members. Basically, from my brief exposure to the types of devices that are available, the devices will actually continue to log and record in its internal memory, even if it loses communication via the mobile carrier. And once signal is returned, it automatically will communicate all that it has logged back to the Central Monitoring Center. At the Central Monitoring Center, all the data that is from the different devices, from all the users, is logged, and it's going to be continued to be logged and kept till perpetuity or as directed by the court, for that person is no longer needed to be
Thank
monitored.
you. And Mr. Boxell, regarding the response time, which is going to be critical, I presume in all cases, but in some even more so, particularly where the conditions of protection order is in effect.
Honorable Member, the police service actively has a grid of patrols 24/7 in all the divisions. It will not be strange to direct information of a breach to one of these patrols who may be in close vicinity of where the breach would have occurred. GPS being what it is, all police vehicles are fitted with GPS. We may be able to look at our grid and see where vehicles are and direct a particular unit to respond quickly and promptly. So to give you what is 3 minutes, 5 minutes, 10 minutes, but as I said, it would be determinant on where our resources are at that point in time, and we can direct the closest resource to respond to a breach.
But I think with respect, the public will be much more comforted if some sort of benchmark time is established and articulated, so that the police service is already facing a confidence issue, and this if executed effectively, can go a long way in restoring some semblance of confidence, especially with a new program like this.
I agree, Honorable Member. The pilot project, when it is implemented, we would be able to gauge response time so that we can apply it across the board when it is done nationally.
We do understand, but let me say this before I give way to Senator Coppin again. I had the opportunity to spend 3 days with the police in Washington back in 2012, I think it was. And I take Senator Richards' point. Right now, unfortunately, but realistically, the public is saying we have little confidence in quick responses from the police, right? That's not always correct, but it's the perception of the public. And I had the opportunity to see, sitting in patrol cars with them, how the thing operates. They're out on the road, there's an audio communication, and there's a computerized communication. So it comes up on the screen at the same time they're hearing the broadcast. And I'm sitting there, riding along. And each of these 15 cars on the particular circuit in which I was, this is how it works, Mr. Boxill. If there are 15 cars in the circuit, at no time will there be 14, because one car will not leave and go off duty until he is satisfied that his replacement comes on for the next shift. So you'll have 16. You will never have 15. You with me?
Yes.
And then when the report comes up, it stays on the system until it is resolved and the patrolman informs the base the matter is resolved. Other than that, it stays up. In addition to that, I, in car number 7, could see all the other 14 cars on the circuit, whether they are in motion or whether they are static. I could see that. Each could see the other. Yeah? Mm-hmm. And once a report comes up, those that are closest to the scene of that report, which is broadcast and seen on the computer, gets to that area. So within moments, we get on a scene and we see 3 other cars. So when the car that gets there first is dealing with the issue, the other patrol cars come up. They will now assess the situation to determine whether they must stay. And certainly one stays. And he or she pays attention to the occupants of the vehicle if it is a road stop, see whether they're throwing anything out or they become, that kind of thing. Even a woman called to report that there was a raccoon in her basement. 3 cars were there, and such like. That is the kind of modern response and policing that this country has been paying for decades and not getting. So I ask you, please, this is not all yours to carry. We are all responsible. We are all responsible. But more directly, the police administration is responsible to manage its resources to bring about that level of comfort, as the senator said. And it is possible. I saw it, and it's happening. We need to get that in Trinidad and Tobago.
And just to add, Mr. Chair.
Yes, sir.
Regarding the use of and the employment of technology, in other jurisdictions, the person who initiated the protection order is built into the system whereby they also get a text message if that person is in close proximity to them. So they are put on guard. In addition to law enforcement being put on guard to investigate the matter, this may also be considered.
Well, that is something that we can factor into the regulations when that is being formulated.
Thank you. Senator?
If I may, with respect particularly to domestic violence, the devices that we have been informed of, in particular for domestic violence cases, there is a device on the perpetrator, as the case may be, and there is also a pocket device that goes on the victim that monitors a range so that the victim is always aware if that range is breached, as well as the monitoring unit. So the victim themselves can take action, the call, as well as the monitoring unit. And that is the design for domestic violence cases.
Thank you.
I recently visited the police station, in the fraud squad actually, and also at the Sinclair police station. And what struck me is that they had a number of information communication technology devices, but for whatever reason, they weren't using them in a manner that appeared to be effective. For instance, on the walls of the police station, they were still speaking to sending your solicitor telegrams. We no longer have solicitors, neither do we send telegrams anymore. Further, when I visited the Sinclair police station, I went to inquire about a lost ID card. And rather than simply pulling up an Excel sheet, the police officer proceeded to open a drawer and look through numerous items, and he could not tell me when these items came in. I thought it would have been a more effective use of his time if he had simply pulled up an Excel sheet, for instance, and then he could have told me whether or not my lost ID card had in fact come in. I'm raising these issues because you all are going to invest at some point in time, the Republic of Trinidad and Tobago in that technology system, which is going to, I suspect, be very costly. What I am worried about when I listen to the contributions of Mr. Dick, for instance, is there seems to be a centralized system that is going to be somehow implemented because of the lack of confidence or whatever in persons of a lower rank, for instance. It got me worried as to whether or not we are simply, one, putting old wine in new bottles, for instance. Are we going to implement a system that is in line with best practice from a management perspective? And is there such a plan, a management plan that the system provider is going to also provide? Or is he simply going to offer a technology solution and leave? Is there a plan so that I don't experience or this system doesn't fall the same fate to other systems or failing systems currently being implemented within the Trinidad and Tobago Police Service?
In terms of the provider will be targeted to provide technical support in developing our procedures, our rules, and our guidelines. So we will be getting that expertise as part of the whole package of bringing a provider on board.
So response times, for instance, if we had this same meeting during the pilot project, there would have been a number of guidelines inclusive of response times, which we can expect to be in place.
Well, I can't predict what the SOPs are going to be at this point in time, but also we have to develop those consistent with our mechanisms and so on that we have it currently in place, right? And the committee will be so advised by the various parties who have to action aspects of the act.
Well, I can tell you from someone who has been in the ICT field, those things are very standard. If that thought has not entered into your contemplation by now, I am very worried. I don't know if the ICT person could assist me as to whether or not they have looked into similar guidelines and response times for systems of this nature to ensure that we don't have a managerial failure when this system is actually procured.
There are two ways to look at response times. One, I thought the question was going in the direction of response in the event of a breach. But from a response time with respect to the system and its performance, that definitely is on the table because this is real time. This is real time we're talking about, real time monitoring of criminals, if I may use that word. So that type of high availability and redundancy is going to be requested in any solution we decide to choose. And we will also be guided by any operating manuals that the potential service provider will have to put on the table because, as you would understand, this type of system is new to us in Trinidad and Tobago.
Well, I think you preempted my question, because my statement that I would like to make, and I have a question after that, is in relation to the response time and using as your benchmark the shortest possible time that an individual will take to breach the device, which means remove the device entirely from their ankle. So if it takes them, let's say, reasonably a minute to cut it off, then you might want a response time of at least a minute and a half, or a minute or 2 minutes to get to that individual. Because if it is that your response time is 10 minutes, when it takes a minute to remove it, then it's wholly and solely ineffective as it relates to Trinidad and Tobago. So maybe the service provider or the person who is providing the devices can give you a guideline as to reasonably how fast an individual can remove that device, and then you use that as a benchmark which you try to achieve a response time. That's just a suggestion for you guys when you're doing a pilot project. The question that I have is, of the 300 devices that you're going to procure, how many of them would be deployed in Tobago?
The pilot project is targeted for the St. George West Magisterial District at this point in time. So those 300 devices will be that pilot project. Subsequent to that, then we will deploy nationwide, right?
Surely it would have probably been better if you distributed this thing around rather than having one district, given the fact that, at least in a pilot project, you'd want to test the range of the system, surely.
Well, in the discussion with the stakeholders and so on, that particular district has a variety of terrain and areas and so on which can test the device. Because somebody is charged and device fitted in that St. George, but does not necessarily mean that they're going to stay within that district and so on. They are allowed to move within Trinidad and Tobago within the inclusion and exclusion zones, which will be tracked and so on as well. But the decision for that St. George West Magisterial District is because we need to have information to act on. And like Mr. Prescott said, we need to test those devices, we need to test the pieces of equipment, we need to fully appreciate the functionality of the system. We need for Mr. Boxell as well to test his response mechanism and so on, test how the courts themselves are going to respond to the system that's going to be set up. So that, as in any pilot is to test your system, test the functionality that if you have designed, and verify whether or not it is meeting that functionality, or do we have to make some adjustments to how we move forward with it.
Mr. Chairman, if I just quickly.
Yes, because we are aiming to wrap up here in a couple of moments, so please.
A quick change in gears, members of the committee. This question, or these 3 quick questions are directed possibly at Mr. Lutchman and Mr. Pulchan. One of the benefits that has come out of these types of systems when instituted in other jurisdictions is a reduction in the recidivism rates because of the sentencing option and the ability for eligible offenders to, in a monitored scenario, move back into the population. Has there been any discussion about how this can more effectively be implemented to increase or increase the efficiency of rehabilitation or the restorative justice aspect of this? Since if that is not done, and we are looking at 300 in the pilot project and possibly up to 1,200 to 1,500 when nationally implemented, it can be either a success story or just play into what is already a dismal account of recidivism rates in Trinidad and Tobago. Has a different approach been taken regarding restorative justice and the debriefing of these possible eligible individuals before putting them into the system, in the pilot system, at least?
The committee fully understands that this mechanism for dealing with persons eligible can lead to rehabilitation and so on. The providers that we have spoken to, the foreign parties, have all provided information that it has decreased recidivism and improved rehabilitation. So the team is looking at that and has been considered all of that. In terms of...
But if I could, what specifically is the plan to increase that that rehabilitation aspect of it. It's not going to happen organically. A different type of approach has to be taken where the rehabilitative or restorative justice protocol in the prisons must take place.
Certainly,
Not because they're eligible and they're fitted with a device. Doesn't mean that they're naturally going to benefit from this.
Certainly, I'll ask Mr. Pulchan to.
Thank you, sir. Honorable member, let me say that the prison service welcomes electronic monitoring with open arms, and we can see great benefit in this because it will greatly reduce our population because there are quite a lot of candidates suitable for this program. Yes, I believe it will assist the rehabilitative process, our reintegrative process also. I think the restorative justice process, whereby we use the country, the community, to assist in the rehabilitation of inmates by placing that person in that community will greatly assist us and also cause rehabilitation with the particular individual.
But rehabilitation starts inside the prison walls. It doesn't it's not effective just by letting someone back out in a particular community. The person must be debriefed and put through a program to benefit from this protocol, in addition to which they must be given an opportunity to work and become productive members of society. Otherwise, they are going to fall prey to necessity of unfortunate criminal activity again.
Yeah. I agree with you, sir. I agree with you 100%. It's a process whereby you will have to work to earn it, perhaps. Currently, we have remission being used in the prison service as a form of rehabilitative tool that will contribute to good order within the system. This is an addition to the remission process, whereby a person could actually go into programs that can deal with their criminogenic factors and look forward towards achieving the electronic monitoring as a benefit. So I think it brings some benefit to us too.
Okay. While I can see that very enthusiastic and contented look upon your faces and your indications that you would like to spend a lot more time with us this evening, I'm afraid that time has run and we must now close these proceedings. I would like, therefore, to invite you, Mr. Chairman, to make any closing remarks that you may wish for the benefit of this committee in light of the discussions that we have shared. Mr. Chairman.
Thank you, Honorable Chair. And I thank you for inviting us to having this conversation with the nation on what electronic monitoring is all about. And I'm hoping that everybody is a bit more informed and educated about what we intend to do. I assure you that the Ministry of National Security and this committee is committed to getting this done in the shortest possible time, understanding the urgency with which it needs to be done. So, thank you.
Well, thank you very much as well. On behalf of the committee, I would like to indicate that a lot of the discussion we heard today reflected deep and burning public concerns about the state of affairs in Trinidad and Tobago and the impact of crime on our society. Someone agreed as we were proceeding in these discussions that there are many people who are not victims of crimes directly, but they are affected by it because we all trouble over it, we worry, we have family members, we have neighbors, and we're reading the papers and watching the news on a daily basis. We recognize that the implementation of the electronic monitoring system managed by the Electronic Monitoring Unit is a very critical piece in dealing with or providing a response to what is taking place in this society. That explains the pressing questions you may have had during these discussions, the reflection of a lack of confidence on behalf of the public in terms of our responses, and our pressing questions as it related to when will this thing happen? That's really the key. In this regard, I want you to urge yourself and your committee to get on with this. Observe and keep those timelines that you shared with us. The country is crying out for it. It may mean having to meet more than once per month. Whatever it takes, it's got to be done. I know that you all serve in other ways on a full-time basis. So we thank you for your service in this committee, but we are depending on you to make this thing happen and in quick time. So this committee would review these discussions, and we may formulate further questions that we want answered, which we will present to you for your response in writing. I assure you that as we glean from our review of these discussions, if we consider that there is anything that we as a committee could do to enhance what you are doing and to ensure that you are able to do it swiftly, we most certainly will. I want to say again in closing that you have to relate to your permanent secretary, who will relate to her minister, and money must not be an impediment, because we can't pinch some pennies and die in the process. And this thing has come to a very sordid state of life and or death in Trinidad and Tobago, as the public feels that criminals are walking all over us, and we depend on you to protect us from them. This is urgent. This is pressing. So again, we would like to thank you for coming. We wish you well, and you will hear from us, as indeed we look forward to hearing from you, and we will be keeping an eye on these timelines, I assure you. We look forward to that advertisement for the additional personnel as you have promised. And we will keep an eye on these timelines, and we will ask you to come to us again if we consider it necessary going forward. On behalf of my colleagues and this committee, we would like to thank you and wish you safe passage to your respective offices, because we suspect you won't be heading home. Good luck, and God bless you. Thank you very much. This public hearing is now at an end. Members, you will retain your seats so you can continue our business, the committee having departed. Thank you very much.